in the matter of the state of Michigan versus Lee Lurma 25-01462. Appearance, please.
Good morning, Your Honor. Cassidy Kachukes for the people appearing and requesting permission to practice pursuant to MCR 8.120 with Maluda Buxi as my supervising attorney.
Jacob Riley on behalf of Mr. Lurma, who is present to my right.
There was a date scheduled for jury trial. I received information that there was going to be a plea to the charge. Is that accurate?
That is my understanding, Your Honor. It would be a plea to charge under 76948 status.
No objections.
That's correct.
Correct. Okay, correct.
Correct, Your Honor.
Okay, is there a plea, advice of rights?
I do have this.
So Lurma, can you raise your right hand? You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, you can put your hand down. Is this your signature? You went over these rights with your attorney. You understand that you have to give up all of these rights if you want to plead guilty to the original charge of domestic violence.
Yes, ma'am.
And that's with the understanding that the people are not objecting to your sentencing under 769.4A if eligible, correct? You understand that you have the right to be presumed innocent until proven guilty, the right to take this matter to trial and have the prosecutor prove your guilt by proving each element of the charges being brought against you beyond a reasonable doubt. You understand that, right? Are those rights? You also have the right to remain silent at any trial, not have that silence be used to prove or imply that you're guilty. Your right to see, hear, or question any witness called to testify against you, and your right to have witnesses subpoenaed to testify on your behalf. You understand that? Do you want to give up each of those rights?
Yes, ma'am.
Is there anyone threatening you to get you to give those rights up?
No.
Anyone coercing you to plead guilty? You want to plead guilty because you believe you are guilty?
Put my hand on her shoulder and it wasn't in an aggressive manner, or even if nothing came from it, it still happened in general.
Okay, it was an aggressive, offensive manner. You
I
say
said it wasn't.
it was not.
But it's still, like, I still put my hand on her shoulder in general, and that's enough to make me want to plead for it.
Well, we'll see about that. Are you pleading guilty because you believe you're guilty of domestic violence?
I touched her shoulder in general, even if I didn't.
Touching someone in general is not a domestic violence. Did you know that? Did you know that?
It said that.
Answer my question.
No, ma'am.
Okay, touching someone in general is not domestic violence. This is not a domestic violence. You understand that? But if you touch someone in a way that's harmful or offensive, that's different.
But I was really angry, so it probably did come across as I was in a harmful sense or something like that.
So you don't believe you're guilty?
I believe I'm guilty.
That was
from what
my
happened.
question. Okay.
Yes, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand that by pleading guilty, it can result in a conviction that you may need to report on a job application, or you may need to report this to your current employer.
Yes, ma'am.
Could have impact on where you can travel or get immigration status.
Yes, ma'am.
As to domestic violence, how do you plead?
Kristen.
Factual basis.
Mr. Lurma, on May 14th of this year, 2025, were you at location 1037 Vincent Court?
Yes, sir.
Is that in the city of Lansing?
Yes, sir.
Was there a person named Maylin Tiffany also present at that place at that time?
Yes, sir.
Is this somebody that you had a dating relationship with?
Yes, sir.
What did you do at that location at that time that would make you guilty of assault against Maylin Tiffany?
We got into an argument and I touched her shoulder and her.
You say touch, what exactly did you do?
More like a caress, but I was really.
A caress?
Like it was like this. And like
Oh,
this.
I'm not accepting the plea.
Yeah, you inquire for.
A caress? Do you know what the definition of caress is, counsel? He's also already made it clear that he really doesn't think he's guilty. He said it, but this is after I questioned him. He said he just touched her shoulder. Just touching someone's shoulder or caressing, like you just did with the palm of your hands, is not a domestic violence. So we need to go to trial.
I want to stick with my lawyer. He told me I should take the plea.
Oh, you don't plead because someone told you to plead.
I just
plead
feel
because
like
you,
that was-
no,
I just feel
don't
like
talk
that
over
was
me.
this one.
You don't talk over me. You plead because you believe you're guilty, but if I can't get a factual basis, meaning you can't tell me what you did to make you guilty of the crime, then I can't accept your plea. I don't accept pleas just to get your case over with.
We were angry, we were yelling at each
What,
other.
no, don't tell me what we were. What did you do to make you guilty of a domestic violence?
Well, we got into arguments, we were yelling at each other. I'd say there was probably a lot of anger in there. I'd say more like grabbed her shoulder a little bit like this, but it wasn't.
You grabbed her shoulder for what reason?
I was trying to get her to like pay attention to me and talk to me because there was a lot going on.
So it was not a caress.
I was talking about to the face that was nothing but the
You
shoulder.
you touched her face too?
Yeah, it says it in the report.
I don't have a police report. Did you know that? Yeah.
I'm sorry, man.
Yeah. What else did you do to her? Where else did you touch her?
I touched on her shoulder. I was angry, so I probably did.
You grabbed her shoulder?
Yes, ma'am.
Yeah, you didn't just touch her shoulder. You grabbed it, didn't you?
Yes, ma'am.
And you touched her face. How?
It was gentle to the face.
A gentle caress on her face while you're yelling at her?
I mean, we weren't yelling all the time, man.
But I'm asking you about when you were yelling. You just told me it was a lot of anger in there. Did you touch her face during that time?
I think so, yes, ma'am.
Okay, so that wasn't a caress then. What was the purpose of you touching her face then?
Try to get her to pay attention.
So you touched her face, she wasn't looking at you?
Yes, ma'am.
So you grabbed her face and turned it toward you, didn't you?
Kind of.
Kind of?
Maybe like that.
No, just soft rub like you were gonna kiss her?
I'd say it wasn't a soft rub, it was like this.
You turned her face back towards you.
Kind of, yes.
So she wasn't looking at you like that, correct?
I guess it was kind of.
Not, don't guess, I'm not gonna take your plea if you play games with me.
Yes, ma'am.
What did you do?
I guess it was something like this.
You don't know?
It was something like that, ma'am.
Do you know what you did?
Yes, ma'am.
What did you do?
It was something like this.
So you smacked her face back towards your direction, correct?
No, I didn't smack her.
Well, what is that you call that?
I was like this. I didn't smack her. I didn't open hand her. Like I didn't do any of that.
But your hand is, her face is not looking at you, correct?
Yes, ma'am.
You put your hand on her face to move her face aggressively back towards you.
I didn't say aggressively.
How was it done? It was sweet? It was caring? I'm trying to understand what the nature of the touch was.
We were in an argument. I moved her face towards me. It wasn't a slap. I didn't slap her.
Okay,
It was like this. Like
that same,
I guess I could tell.
in that same motion, nice and soft like that, or was it more?
It wasn't a slap. Like it was like this. Like it wasn't a lot. I'm saying with the stuff that happened with the face, that I don't think that was.
And then put your hand on her
On her
shoulder?
shoulder, yes, I was angry. I might have gripped her shoulder a little bit. Like I
Okay.
might have.
Any additional factual, and this wasn't in self-defense, correct?
No, ma'am.
Any additional factual basis?
She did not want you to make that comment, correct?
I guess not. No.
You guess not?
I'm guessing.
You think she
didn't.
wanted you to do that?
I'm guessing not. No.
You don't, no.
I don't think she would want me to do that.
I have no questions. Your Honor.
No further questions. If you do not.
I'll accept your plea if I your plea to be voluntarily and freely given. Although not 100% forthcoming. I shouldn't have to do all of that to get a factual basis out of you. If you believe you're guilty, you tell me what you did. If you don't know what you did, then you can't plead. But if you know, don't try to manipulate the facts and tie up time and try to make yourself look or appear like you did something less than what you did. You're being charged with a domestic violence. I don't have the police report, you have it. And the victim will have an opportunity to give a statement at the time of your sentencing. Your matter is scheduled for sentencing on October 6th at 9 a.m. When you leave here, you go downstairs one floor to our probation department and check in. They're going to get you set up for a pre-sentence interview. They'll advise me if you are eligible for 769.4A, and then try to get a victim impact statement from the victim. You can appear, well, I want you to appear in person for your sentencing. How old are you?
18.
Are you in school? Any additional matters for the record? Oh, Mr. Wonderful.
Yes. Thank you.
Nothing from the defense, Your Honor.
Nothing from the people, Your Honor.
You're all set, thank you. Is Mark Anderson downstairs?
He's in custody, Your Honor.
Name, put him on Apple Jackson. Oh, okay. This is the state of Michigan versus Patrice Jackson, 23-02956. Appearance, please.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Jackson, who joins us via Polycom today.
Ms. Jackson, can you hear us?
Yes, ma'am, I can. Yes, Your Honor.
Okay, this was a final pretrial for larceny. Did we resolve this or we continue to trial?
Your Honor, there is a resolution. I think we're filling out a plea sheet right now, but I can summarize it for the court verbally. The people are offering to amend the charge from larceny 200 to 1,000 to larceny under 200. I think there's also an agreement to time served, although the state can correct me if I'm wrong there.
It's no objection to time served,
No objection. to time
not
served.
an agreement, but
Yes.
yes.
There may be some restitution sought. We are still determining what that restitution is, as what the police report indicates cannot be what the restitution is. So we may be asking for a restitution hearing set separately, but I believe that is the summation of the offer. It is Ms. Jackson's intent to accept it today. Would you like the PAC codes on the plea sheet, or is?
Yes.
the name?
If you have. Ms. Jackson, let me have you raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I do, Your Honor.
You can put your hand down. In this matter, you have the right to proceed to trial and you have the right to a jury trial. You are presumed innocent until proven guilty, and you have the right to require the prosecutor prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, Your Honor, I do.
You have the right to maintain silence at trial and not have that be used to prove or imply that you're guilty. Your right to see, hear, or question any witness the prosecutor calls to testify against you. Your right to subpoena witnesses that will testify on your behalf. You can waive your right to silence and testify at your own trial if you like as well. You understand those rights?
Yes, Your Honor, I do.
And you want to give up those rights today in order to accept the offer?
Yes, Your Honor, I do.
Okay, are you still on probation?
No, Your Honor.
As far as I'm concerned, as far as I know, no, I don't believe so. I believe that was waived. Revoked.
Okay, you understand that? You understand that by pleading guilty, It could result in a conviction that you may need to report to your future or current employer.
Yes, Your Honor, I do.
It also could have impact on where you can travel or get immigration status in the future. You understand that?
Yes, Your Honor, I understand.
And do you want to enter a guilty plea to the amended charge because you believe that you are guilty?
Yes, I do, Your Honor.
As to the amended charge of larceny, less than 200, how do you plead?
I plead guilty, Your Honor.
That was factual basis, please.
Thank you. Ms. Jackson, is it true that on or about July 20th of 2023, you were present at or near 421 Dorrance Place?
Yes, ma'am, that is true.
And is that in the city of Lansing, in County, Michigan?
Yes, ma'am.
And at the time, did you take a piece of property, specifically a bike, that did not belong to you?
Yes. Yes, I got
And you
I
did
did.
so, and you did so without the agreement of the owner of that vehicle, correct?
Yes, that is correct.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any additional factual basis from the prosecution?
Just one additional question, Your Honor. And that bicycle had some value, correct?
I don't know if she
Ms.
heard you.
Jackson, the question I was just asked, that that bike had some value, correct? It was worth money.
Yes, it was.
No further questions from the people, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. Is there a victim here today?
The victim is here today, Your Honor, yes.
Okay. Okay, we can proceed to immediate sentence.
Thank you, Your Honor.
Does the victim want to make a
May I
statement?
go ground the victim to see if they'd like to make a statement?
And I did know Ms. Jackson specifically wanted to.
And there was no restitution, correct?
We are
There may be, Your Honor,
unsure.
but we don't know.
I will ask the victim on the way here. I know.
That's information we need today.
I talked about it with Ms. Fortuna Gill at the last hearing.
The other people is weird as fuck. Trucking people with some dumb shit. Lock people up for shit they ain't even do.
Who are you talking to? Mr. Diaz?
I was talking to myself, man.
Oh. Don't talk out loud. You're in the middle of a courtroom and we're on the record.
I apologize.
And the victim is present in the courtroom now. I spoke with him on the way into the courtroom, and it sounds like we are not concerned about restitution. So we'd be okay with the victim would be okay with an order of $0 restitution.
Okay, and the victim do not wish to make a statement?
No.
Okay, I need to make allocation.
Thank you, Your Honor. I'm going to talk largely about what Ms. Jackson has done since this incident occurred. In speaking with the state, it seems the primary concern of the complaining witness, which is a fair one, was some drug addiction issues that Ms. Jackson has been dealing with. She also agreed it's something that she struggled with for a very long time. And so when she came into the custody of Ingham County Jail, she decided to try and treat this situation not as an embarrassment or a frustration, but as an opportunity to take advantage of whatever kind of growth she could. To that end, what she did almost immediately upon coming into her custody was get involved with cats.
Yes.
Permission.
Okay, I'm sorry.
She has remained involved with the CATS program at the Ingham County Jail for the entire time she has been there, which I believe is early July. She has also spoken with a caseworker at Great Lakes Recovery about entering an outpatient program with them outside of the court. I don't believe it's an order of the 55th District Court that she participate in this. It's just something that she wants to take advantage of so that she builds a better life for herself than the one she's been experiencing for the past couple of years. She has enrolled in the Suboxone program in the Ingham County Jail. She's talking about how excited she is to not be feeling those same urges and addictive cravings that she has for the past few years. And she appears to be a much more lit up, hopeful, positive person than she was even a month ago. And a month ago, she was talking about her kind of hopes and plans to put herself in a better position so that she doesn't do to this young man what she did to him a couple of years ago. And I'll end it there, Your Honor, because Ms. Jackson very much wanted to make a statement to the convicted here today.
Ms. Jackson, you can address the victim at this time.
Hi.
So he's sitting here behind you, Ms. Jackson. He can hear you.
Okay, hi, hello. I just wanted to apologize. I can't remember much, but maybe you don't even remember, but you helped me before. While I was out in the streets of my addiction, and I just want to let you know that I am absolutely and completely very apologetic and very much remorseful. And I just wanted to thank you for being different, for actually helping me. And I hope that you can forgive me. And that wasn't really me. I did not mean for that to happen. That was not my intention. But I wanted to take complete ownership on whatever I can do to make amends with you. I would love to do so. And I just hope that I have this way to change your heart towards other people like me who are out in the streets, lost and strung out on drugs and not really thinking logically. You have a great heart, and I think you're a very beautiful person. God bless you. That's all you got.
I appreciate it. I actually struggled with cocaine addiction personally. So I don't know, but I knew you by Brittany, I think. But anyways, I really appreciate, what you just said. There's all the forgiveness and the hope that we all move on to a better place. So thank you very much. I appreciate it. God bless.
Sir, what's your name for the record?
Christopher Wayne.
Thank you. And thank you for taking the time to make amends. And it appears that Ms. Jackson is remorseful. I believe her to be genuine. I don't have her criminal history at this time, which typically I would have for an immediate sentencing. My understanding, at least at the last court hearing, is that she was on probation but in Ingham County Jail at that time on a violation. So she's been revoked from that.
Yes, Your Honor. If I remember correctly, our last hearing was on the 10th. She had a hearing in the 55th District Court on the 14th. At that time, her probation was revoked. She was given 90 days, credit for 45. And she requested an order to get involved in the CATS program at that time. So I think she's getting close to the end of that sentence, but she is still currently serving it.
Okay, she originally in this court at least had $100 10% bond for some reason.
Because she was already in custody elsewhere, we were trying to avoid that time at arraignment.
I was gonna say her, and then there must have been a request to amend her bond at the last case because it was amended to a 100 personal account.
I'm guessing what if she was sentenced to a sentence to serve in jail in the 55th District Court, she was gonna be dead time anyway.
Don't worry about it, David.
Oh, sorry.
So it looks like she's definitely had some time on this, and she's not going to be immediately released.
That's correct. She's got, I think, a couple more weeks to go, Your Honor.
Creditor time served. There is, however, a $75 crime victim rights fee plus a $50 state minimum cost that I cannot waive. So those will be assessed, and she can make arrangements once she's released from custody to pay that. Okay.
Ms. Jackson, once you're released from custody, you're gonna call the 55th District Court about how to pay that $125, okay?
54A, call 54A, not 55th,
Oh, sorry.
okay?
Forgive me, please, could you? I apologize, Ryan, go ahead.
Once you're released from custody, you'll call 54A District Court so that you can make arrangements to pay the fines and costs on this, okay?
Yes, ma'am.
What's your address?
I'm sorry,
What is
could you please say
What is
that
your
again?
what is your address?
My
you
address
need
is
to-
5913 Highgate Street, that's my mailing address.
Okay, we'll send a notice of show cause after 30 days. You okay?
Yes, ma'am. God bless you, thank you, I apologize about the light.
No, the light is because you're not moving, so you got it, or you're saying you're apologizing about the bike. He accepts your apology. You need to get up and move so that the light in the jail comes back on, okay?
Yes, ma'am.
There you go. All right, you're all set.
God bless you, thank you for accepting my apology, sir.
State of Michigan versus Jamonte Gates, 25-01987, appearance, please.
Good morning, Your Honor. Cassidy, student for the people.
Or Your Honor, Assistant Public Defender Lawrence Sutter on behalf of Mr. Gates, who is approaching council table now.
This matter was scheduled for final pretrial today on a domestic violence. We have the necessary witness here.
Yes, Your Honor, we do.
Okay, I have a bond violation here that you need to be arraigned on. The allegation, sir, that you allegedly violated the terms and conditions of your bond. Specifically, the no contact with third party means by making contact with a third party to the protected party. On or about the time, it's like of July 4th and August 6th. I have a report here. Counsel, did you get a copy of that?
It looks like my paralegal uploaded a file this morning to it.
So you have the right to have a contested hearing on that violation or those violations. It's technically two allegations of contact. If you're found to be in violation of your bond can be revoked. You could be remanded to jail pending this trial. You understand that?
I understand.
So the court's going to enter a plea of not guilty for your client, correct?
Yes, Your Honor, thank you.
So we're continuing to trial or how we proceed?
We are continuing to trial, Your Honor.
Okay, this matter is scheduled for jury trial September 8th at 8 a.m. We'll schedule the PA 53 for that time as well.
Thank you.
Do you have any questions for the court today, sir?
No, Your Honor.
Okay, I'm going to remind you of the no contact order. You're not to have contact directly or indirectly with the protected party. Is it Michaela?
I think it's a hyphenated last name.
Michaela Zamatis Lupino. You're not to have anyone send a message for you to her. Do you understand that?
I understand.
Okay, you're not to be wherever she lives, works, or goes to school. It does look like there was third-party contact allowed by the magistrate in reference only to the minor child. But anything else would be in a violation of your bond conditions. I don't think you want to sit in jail pending your hearing, do you?
Absolutely not.
Okay, or pending your trial, okay. So be compliant so that there's no issues. Do you have any questions about your bond condition? Okay, any additional matters for the record?
You're
Nothing.
Thank you, you're all set. State of Michigan versus Tempest Goodman Stevens. 5-01929, appearance.
Morning, Your Honor. Can I speak to you for the people?
Jacob Riley on behalf of Ms. Goodman Stevens, who is present to my right, Your Honor.
And this was the final pretrial for domestic violence. Is the necessary witness here?
I have not had contact with the necessary witness, Your Honor. I've not seen him here today.
Defense motion will be to dismiss.
Motion to dismiss is granted, but without prejudice. The people do have the right to reissue this against you within the statutory timeframe, okay? Do you have any questions? Ma'am? Get your dismissal in just a moment. State of Michigan versus William Kirby, 25-01240. Appearance, please.
Your Honor, can I speak to you for the people?
Jacob Perone on behalf of William Kirby Brown.
Kirby was scheduled for final pretrial for an assault and battery. The necessary witness here.
I have not seen the necessary witness today, Your Honor. I contacted them on Friday. He said he would be here, he would have somebody else bring him here because he was not properly served. But I attempted 2 calls earlier this morning and received no response. But he had assured me he would be here, so but he is not here at this time, so I'd expect a motion from the defense.
Yeah, this case has been going on for a while. Make a motion to dismiss.
Motion is granted without prejudice. The case can be reissued against you, okay? Do you have any questions? Make sure this moment.
Thank you. They just go get the tether off.
Yep, you can go notify
They had
them.
the tether off, or but they kept them on a tether. They put me back on it.
I reinstate the bond without GPS tether on July 14th.
Thank you, Your Honor.
Security out there. Is there no security out there?
No, I see.
There's no security out there.
They got him at the.
Oh, okay.
I'll bring you a copy of the, I got you, sorry.
It's Monday. Okay, let's see. They put Anderson on yet?
Somebody is in the post-4, but it's dark. So.
Who's in the jail? Please stand up and move your body. We gotta call and find out what's going on in post 4. Who's representing Mr. Diaz? Was she talking to someone
I think
else?
she was dealing with the gentleman in the hall that was yelling.
Is that her client?
Might be, I'm not sure, I'll ask her.
But she's not dealing with it. She's talking to somebody right there. She's not dealing with the person in the hallway. Do you need to speak to Mr. Diaz?
You know, I haven't spoken with him this morning. I spoke with him in my initial interview a couple of weeks ago, so he knows the plan for today.
Okay, this is the matter of the state of Michigan versus Nicholas Diaz, 25-02385. Appearance, please.
Morning, Your Honor. Cassidy Kachukas for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Diaz, is joined us via Zoom.
For some reason, I don't know that we got an appearance from your office on this, Ms. Sutter.
I'll ask my paralegal to ensure that another one gets sent. Looks like our initial one was sent on August 8th.
Okay, and so this matter was a domestic violence pretrial. I'm assuming we're going to final pretrial.
Yes, Your Honor.
There was no offer at this time.
No, Your Honor, not. I do not believe the defendant is eligible for 7694A, so there is no offer at this time.
Final pretrial, October 6th at 8 a.m. October 6th, 8 a.m. in person at the court for final pretrial.
Trial. November 3rd.
November 3rd, 8 a.m. for jury trial in person at the court. Mr. Diaz, do you have any questions about?
One more time, ma'am, please. I didn't really get to hear you.
I'm sorry, you couldn't hear, you said?
Ma'am, I could not hear you.
Okay, your final pretrial is going to be in person at the court October 6th at 8 o'clock in the morning. And then you have a jury trial in person at the court November 3rd, 8 a.m. in person at the court, okay?
Yes, ma'am.
Do you have any questions?
Oh, that's it.
Any additional matters for the record, counsel?
Not from the people, Your Honor.
Nothing from defense.
You're all set, sir.
Thank you.
Thank you. Did they say who was in post 4?
They're still frozen. Let me call them back.
State of Michigan versus Michelle Washburn, 25-01503, 25-02044, 25-02045. Appearances, please.
Morning, Your Honor. Cassidy Jukes for the people.
Jacob Rowley, we have Ms. Washburn, who is appearing remotely by Zoom.
Okay, Ms. Washburn has a dog at large, a dog malicious destruction of property, and a vicious dog.
Your Honor, at this time, for the defense, for our part, we'd be requesting adjournment. The report we received makes some mention of photos that we have not received yet, so we'd be looking for those before we proceed.
You said you were looking for photos from whom?
Through discovery from the
Okay.
prosecution.
Okay, so you just need a adjournment for that, not additional time for there to be some other negotiations and or
Would use
reply
the time to
net.
pursue other options, Your Honor, but at this time, we need to see what the evidence is.
Okay. We'll set it for a second.
September 8th at 8:30.
September 8th at 8:30. Do you have any questions for the court today, Ms. Washburn?
You said September 8th at 8:30?
That's correct.
Okay, is it in person or Zoom?
You can
Zoom?
appear via Zoom. I think you're hearing your echo, but yes, you can appear via Zoom.
September 8th, 8:30. And would it be the same link I'm using today?
That is correct.
Okay, cool. Thank you.
No problem. Any additional matters for the record, counsel?
Just to put an offer on the record, so we have it, even though they need discovery still. The current offer is that Ms. Washburn would plead to 1 count of dog at large. We would dismiss the balance, and we would be, we would not be objecting to fines and costs.
Would not be objecting to fines.
I haven't actually. We can agree to fines and costs. I apologize. I didn't actually get that approved.
I'm not understanding what that means. You can agree to fines and costs.
It would be a sentencing agreement to fines and costs for the
It's a dog at large.
Yes, Your Honor, but
Don't
just,
put people in jail for dogs at large.
I know, Your Honor, just to be clear for the record.
Oh,
that's all.
so the offer is plead guilty to 1 dog at large, dismiss the other, and dismiss the, what are you gonna do with the malicious MDOP?
Same with that as well, Your Honor.
Dismiss that as well?
I've spoken with Vic on that, yes.
No restitution on that?
That is correct, Your Honor.
Okay, I will see you at your next court date, Ms. Washburn.
All right, yep, at September 8th.
That is correct.
All right, yep, I will be there.
Thank you. I don't think this is on my- It was. This is the state of Michigan versus Delisha Lockett, 25-01858. Appearance, please.
Good morning, Your Honor. Cassidy Kachukis for the people.
Yeah.
Lauren is in here though.
Yeah, I'm in the breakout room right now. I'm just waiting for her.
You're still meeting with her?
I was just waiting for an answer. We're ready to go on her now.
Oh, I think I just requested her back.
Ms. Lockett, you're free to go back to the virtual courtroom.
They didn't tell us who's in post two,
Uh,
visit board.
this
I'm
what it didn't,
removing him.
okay.
This is the matter of the state of Michigan, Delisha Lockett, appearance, please.
Good morning, Your Honor. Cassidy Kachukis for the people.
Good morning, Your Honor. Assistant Public Defender Laura Sutter on behalf of Ms. Lockett, who joins us via Zoom.
Okay, Ms. Lockett has a dog at large and an unlicensed dog. How are we proceeding on this?
Your Honor, it's my understanding that the dog has already been surrendered, therefore, the people are going to dismiss this, are going to be dismissing it this time.
No objection, Your Honor.
What's the name of Molly? Or dismissal. Okay, the case will be dismissed. Do you have any questions, Ms. Lockett?
No, I do not.
You're all set. Thank you.
Thank you.
Who's on the iPhone with the bandana on their head?
Dontrell Trainer.
Your Honor, Mr. Trainer is a victim and also a witness for the restitution hearing that was set for 9 o'clock.
Are we having a restitution hearing?
I believe defense was going to agree to the amount that was submitted in the estimate by Mr. Trainer, so I don't believe there is a need for.
I was gonna say, because I don't do hearings via Zoom, so he would need to come in person.
I would agree with that, Your Honor. However, there was an amount discussed this morning between myself and the people that will be agreed upon by Mr. Bontter. Does the court need it?
Yes.
Oh, sorry.
Let's see, state of Michigan versus DeQuavis Blakes. Is DeQuavis Blakes here? Is Marie Clark here? Marie Clark. Charles Nichols present. I guess nobody showed up for show cause today. Amber Thomas. Are you Amber Thomas? Oh, okay, state of Michigan versus Amber Thomas. You can come forward, 25L2925762.
Your Honor, Cassidy Kachukis for the
This
people.
is a show cause.
I'm sorry.
No worries. This is a show cause. It says that you failed to comply with the payment plan. You have a balance of $175. Let's see. You were originally supposed to pay $50 on June 4th. It looks like you must have more than one ticket. It says 25 each ticket.
Yeah, I
Balance.
have two.
You have 2 tickets? Oh, that's the other one. That one's in warrant status. Got it. I also have 25L2925762. So you're supposed to pay 25 each ticket, and then Your balance on this one is 110, it looks like. Are you working?
No, I'm not.
How long have you been unemployed?
I haven't been employed since April.
What is your plan for employment?
I've been applying to jobs almost every week. And I've been trying my best and nothing's really came back. And then my child's father stopped helping me with child support. So that is another thing that's been an impact on helping me with things.
Okay. Let me reset this for 60 days. I'll give you time to continue to look for employment, okay?
Okay.
You said you've been unemployed since April, correct?
Yes.
November 17th at 9:15.
November 17th at 9:15, that's gonna be your next show cause date. If you pay them off before then, you don't need to appear. But that's just for me to determine your ability to pay, okay? All right, you have any questions at this time?
No.
We're gonna get you a notice to appear and you'll be all set, okay?
Okay, thank you.
You're welcome.
They're putting Mr. Anderson back in. You gotta call back in to us.
Oh, okay.
Yeah, they had me going.
How are you?
Okay.
First time.
Well, you came in on a nice, fun Monday.
Yes, thank you. Good to see you.
You too. You too.
Take
See you
care.
soon. There's a state bar now, so. But, so there's power of a relation, but not enough that she gonna pay the thing. Just so it's clear. Okay, let's see, since you get this ability to pay. Are we ready on Bonter?
Yes,
Just double checking. Yep.
Okay, State of Michigan versus Timothy Bonter, 25-00735, appearance, please.
Morning, Your Honor. Can I speak?
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Bonter, who is standing to my right.
Okay, this was a sentencing scheduled for today. I have a pre-sentence report prepared August 12th. Council, did you get a copy?
I did, Your Honor.
Do we need to make corrections, updates, or deletions?
I do not believe any are necessary at this time.
I do not believe our office did get one, Your Honor.
Haley?
Haley may have gotten it, but she's, yeah.
I have noticed that half time I get sent to Haley, half time I get sent to Mr. Nagel, so let me double check real quick.
Mr. Mayo?
I
Yeah.
wouldn't.
Yeah, we wouldn't send it to Mr. Haley.
Yeah, I got one on Friday that was to Mr. Nagel.
Mr. Nagel was in our office on Friday, or our courtroom on Friday, but
Oh, no, I just doubt they've changed their notes from a year ago when he was here.
It's,
we,
if it
no,
went
we
to-
send it.
Yeah, yeah,
My,
it went
my
to Haley.
Oh, no,
assistant,
yeah, you sent it to Haley. Yeah.
my judicial assistant sends them out. She
Yeah.
knows who's sent it to.
Yeah.
Nonetheless, there was a report that was prepared. Your office probably received it. You just have not
Yes.
received. it.
Yeah,
Okay.
That is correct.
I can forward it. You just,
Yeah.
okay.
Okay, we need to make corrections, updates, or deletions.
I do not believe any are necessary.
I don't believe any others.
We can make allocation.
Your Honor. I did review this report with Mr. Bontter. I agree completely with the probation officer's impressions here of Mr. Bontter. You know, not just being kind of respectful throughout the interview, but also in every communication with me, every communication with the court, every communication with probation, he seems to be entirely able, willing, and desirous of stepping up and taking accountability for the actions that he participated in on this day. He completely agrees that they were not up to his typical standard of behavior for himself. He talked about how he was going through a particularly rough time of life at that moment and was not making perhaps the best choices. And what he's done since then is a lot of work on himself, his life, his surroundings, his actions, to put himself in a position where he is in another world of mindset than he was at the time. From gaining good, stable employment, that's put him in a more stable place of life, to also getting assistance in other ways that make sure he's never in the mindset that he was on that day. He is apologetic and remorseful for the actions he made on that day that led to the damage of other people's property. He knows what it means to struggle to have things of his own. And I think he's pretty regretful of the fact that he put someone else in a position of they didn't have something that they'd worked hard for, or not in the state they would have wanted to have it when they worked hard for it. To that end, Your Honor, I don't think this is an unfair report. I would ask the court to consider a term of non-reporting probation for Mr. Bontter in order to maintain his employment that he's gotten for himself, to make payments on the restitution to Mr. Trainer. We do have that restitution sheet available for the court here, and to otherwise remain compliant with any other state laws in terms of probation. If the court is desirous of him being on some term of probation, I would ask the court to consider perhaps a shorter term of probation, something more like 4 months to kind of get through with what probation wants him to do, so that they can check on him, make sure that he's doing the things he needs to do to keep himself in a better place. I would also ask the court to remove the condition of submitting to random PPTs or urinalysis. I don't think it's called for in this case. I don't think he's a person for whom it's a concern, and I would ask the court to consider waiving that condition if he's put on a term of probation. Thank you.
Okay, I added that to the list.
Siri likes to hear from me.
I just apologize to everyone involved. I wanted to apologize to the person that I destroyed the property of, and really to everyone here. I just apologize for the situation that I'm in.
You didn't go through undergo a substance abuse assessment, correct?
No, Your Honor, it wasn't requested.
That is my concern. It's the nature of the incident. This took with it pure options. Yes.
Yes.
Okay. And so my concern is that obviously this took place at a place where you received drugs and substances. And that when he was denied access because he didn't have whatever identification they wanted, that he resorted to the action that brought him here. And this is someone who has, in my record, never been in trouble ever.
Correct.
And so to me, to get that upset, not because you can't get food, but because you can't get marijuana, that warrants for me a substance abuse assessment. And so because of that, I am going to adopt the recommendation order that he undergo and submit to a substance abuse assessment first. If the assessment shows that he's low risk, then I won't require random alcohol or drug testing. You waited 30+ years to not get in any trouble, and then you get in trouble over access to a marijuana place. Maybe your relationship with marijuana is the problem. I don't know. But we got to figure out what it is that would cause you, someone with such a clean record, to resort to this nature of behavior.
You can't, you don't have to.
No.
So again, I'm going to adopt the recommendation. It'll be for a term of probation. I'm gonna order 6 months at this time of probation. While on probation, you need to maintain your employment and provide evidence of that. I'm gonna order that you do a substance abuse assessment and follow any recommendations relative to that assessment. We're gonna have to get that assessment within 30 days, okay? So you need to schedule that immediately. Okay. And probation will give you information about where you can get that scheduled. You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess firearms, ammunition, or weapon of any kind. I am going to order that you submit to random preliminary breath testing and your analysis testing. Do you have a valid medical marijuana card?
I do not.
You're not allowed to use or possess alcohol, marijuana, or controlled substance without a valid prescription. You're not to be in any bars or nightclubs. And I'm going to order that you participate in mental health counseling.
May I just clarify something on?
Yes,
So you had indicated, must do an assessment. If the assessment doesn't indicate an issue, then testing won't be ordered. So the must submit to random testing, is that until the assessment is completed?
correct.
Okay, thank you.
Do you have any questions?
I do not.
And you said there was restitution.
Yes, Your Honor, we completed the computer. I may have corrected.
Yes, thank you. Thank you. Okay, so it looks like you owe Mr. Trainer $894.64. I'm sorry, 63 cents for damage done to his property. That will be ordered. There is a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost that must be assessed. There's a $30 equivalent oversight fee for each month of probation, so that's $180. I'll waive discretionary fines and costs. When do you intend to pay this $894 back to Mr. Trainer?
Within just a day or two.
We, just for the sake of safety, have until the end of the week for him to do it.
So your total fines and costs are $1,199.63. Once you pay that restitution, that'll obviously drop your remaining oversight down substantially. Lastly, there's an advice and rights as to probation. It states you're being placed on the term of probation before the 54A district court, and your terms are individually tailored to address your specific risks and needs. You have the right to request early discharge from probation once you've completed half of the original term ordered by the court. You have the right to have a hearing, or if I said something, that is, you have the right to have an attorney representation for that hearing, but you do not have the right to have an attorney from the public defender's office representation. You understand that? Okay, I have never held a hearing for early discharge, so you can request early discharge by using the court's MC 512 form. That's on the court website, or you can get it from your probation officer, or your probation officer can fill out the form on your behalf. If you do it, you need to make sure you serve a copy on the probation department, and then also on the prosecutor's office, okay?
Gotcha.
The
Okay.
prosecutor has 14 days to respond in writing if they object to your early discharge. Do you have any questions?
I do not.
Any additional matters for the record today?
Not from you, Your Honor.
Nothing from defense.
Thank you. You're all set.
Drive it and drive. Oh. You was. Anyway. So, what's this? He took the remote control. So I can't, this
Who are you
message.
talking to? Who are you talking to, sir?
You, man, where are you at? Where's this child?
You're talking to yourself. You weren't talking to me. I'm not looking for
Oh.
any remote.
Yeah, I was talking, right, now I'm not talking to nobody.
Oh,
Who's
okay.
Brandon Dennis? Is this my lawyer?
What's your name?
My name is Mark Anderson. Where's the judge at?
Yeah, sorry, it's coming through like this. I don't understand.
Oh,
You're talking
never mind.
Oh my gosh. You're talking to the judge, sir.
No, I know, I'm sorry, man. I see you now.
Brandon Dennis,
Yes.
place your
Oh.
device on until I call you.
Actually, Your Honor,
Okay.
can I
Okay.
Well, he's talking, and when I was trying to talk to the guy in jail. Who's, okay, I guess he just, who's Antonio Anderson? State of Michigan versus Antonio Anderson, 25-02356.
Morning, Your Honor. Can I speak to you for the people?
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Anderson.
No, Ms. Anderson is present via Zoom, and this was an assault and battery pretrial. Was there an offer at this time?
There is not one at this time, Your Honor. I need to have discussions with the victim to be able to have those discussions with this side.
Final pretrial?
Yes, Your Honor.
Final pretrial, October 6th at 8 AM. Trial, November 17th.
Okay, Mr. Anderson, your final pretrial is going to be October 6th, 8 AM. You must appear in person at the court. And then your jury trial is scheduled for November 17th in person at the court, 8 AM in the morning, okay?
You said October 6th?
October 6th is your next court date. You must appear in person.
Okay, thank you.
No problem. Do you have any questions?
Nope.
Any additional matters for the record?
Not for the people, Your Honor.
Nothing from defense. Thank you.
Thank you.
Thank you.
Who's representing this guy?
I represent Mark Anderson.
You need to speak to him?
I do, please.
Please log in. Meet you all. Break up. I think Mr. Dennis is in your room.
Thank you, Your Honor.
Let's see. Motion. James Ward. A show cause. No problem. Let's see. That was the bunch. Dennis. And so they never put Anderson on.
That Mark Anderson is just who that I would rally.
Oh, okay.
Somebody can visit post 2 still, but I just heard noise.
Who's in the jail?
Davis, I'm like,
Stand up and move your body so that the light comes on. That's fine.
Camera, not the light.
Oh, you need to let the deputy know that the light's not on.
Okay.
Yeah, she got, that's his morning.
I'll go already. Cover. I didn't do none of me on bacon. No, pause my phone. Is we live yet? Can y'all hear me? No, cool. All right, thank you. Damn. I'd rather be in court. This is weird. I get used to it. What? What's this doing? Yeah. So, income, until comes. D for a court three. God damn. Whoa, I gotta go.
Whoa, sir, who are you talking to?
Oh, no, I didn't see. I didn't know you could hear me. I know
Yeah,
how to
we can
be
hear you.
quiet.
You're in the middle of
I'm
my
sorry,
virtual
ma'am.
courtroom.
I couldn't hear nothing.
I shouldn't have heard anything either. You shouldn't have been talking to yourself, and you sure enough shouldn't have been swearing in my courtroom.
Okay, I'm sorry. I will never do it again.
Does your
didn't
client
know
need a
you could hear me.
competency evaluation?
That is likely the path going forward.
That was my understanding.
Okay, this is Mr. Dennis. No, Mr. Anderson.
Mr. Anderson.
Mark Anderson.
This is the state of Michigan versus Mark Christian Anderson, 23-01522, 23-02918, 25-01805, 25-02000. Appearance, please.
Good morning, Your Honor. Cassidy Kachugas for the people.
Jacob Riley on behalf of Mr. Anderson, who appears remotely from the county jail.
Okay, Mr. Anderson has an aggravated assault, another assault or assault and battery, another assault or assault and battery, and 2 counts of assault and battery. And based on my interactions today, I believe he might need a competency eval, but you've spoken to him more. Counsel, how are we proceeding?
Your Honor, our request would be an adjournment of all these matters so that we can petition.
Something like that, man. Sorry. Sorry. I'm sorry, man. I don't want to do it no more. I'm sorry.
And he was just arraigned on something new this weekend or picked up?
He was arrested over the weekend. He may be facing the charges. We don't know exactly what.
We've issued them, but I don't believe they've been sworn to yet. I can tell you what the charges were. It's resisting and obstructing and unauthorized use of the 911 call or 911 services.
What?
Okay. I'm going to amend his bond on the aggravated assault. I'm remanding him for a competency evaluation. And the case will be stayed pending a report from the forensic center. Any additional matters for the record?
Just that we are pursuing a mental health court resolution if Mr. Anderson is found competent or is restored.
Okay. Any additional matters?
There's nothing from the defense, Your Honor.
I'm gonna go.
Mr. Anderson,
I'm not talking to you. Oh, I'm sorry.
I recognize you're not talking to me. You need to talk to the
Okay,
deputy and tell him you're all set.
Where you at?
He's over there where you are. He's not over here with me. Go to the door
That's
and
my
let the
lawyer.
deputy know you. Excuse me? Okay,
That's
never
my
mind.
lawyer right here.
We'll call the jail and tell them you're all set. Oh, this was a final pre-trial on this one. You can obviously get rid of that jury trial. Yeah. What was I just signed a nominee for ISA, correct?
Yes.
What is this violation for? It's not for picking up a new case, is it?
Sorry, there's about one more time to dismiss my last witness. That's all right.
Can someone else dismiss your witnesses so I can call this here?
Absolutely not.
This.
Yeah.
Okay, on the record in the matter of the state of Michigan versus I have a Carmen Kelly, AKA Carmen Napolet, and then a Carmen Sawatu. These are file numbers. Actually, I don't have file numbers. Council opinions.
Your custody chief for people.
And good morning, Your Honor. Lorna Mosier with Legal Services of South Central Michigan. I'm appearing on behalf of Ms. Carmen Raphaela, P86550. She's appearing on my right.
Okay, I recognize she's Raphael now, but what is she on this record?
Ms. Raphaela.
It was Carmen Kelly on the application, correct? On one, and Carmen Napolet on the other, correct?
That is correct. Those are prior names from prior marriages.
Okay. And so today was the date that we reset the motion to set aside conviction. I noticed that we have proof of service filed on both now, and we do have a opinion from the Attorney General on both. There's no objection. Is the prosecutor taking an opinion on these or position?
No, Your Honor, we are not. I was unable to locate anything in our files regarding these cases.
You have a proof of service, so they were served.
Oh, I meant regarding like the actual file itself. Or the
Okay.
original, it's not the.
Got it. Yeah, the one is a retail fraud third degree from 2000. The other was a retail fraud third degree from 2007.
We take no position.
This is typically no position. Okay, let's see. Counsel, did either you or your clients explain what your client's been doing since the time of these convictions?
Certainly, I can give an update on Miss Raphaela's life. So Miss Raphaela has had some pretty dramatic changes in the past, 10 years or so. She is, I almost don't know where to start. She has gotten a bachelor's degree, is that right, or associate's?
Associates.
She's received her associate's degree in 2022. She's currently pursuing her bachelor's degree from Western Michigan University. She founded a nonprofit about 10 years ago in 2014 and has continued to work to advocate for vulnerable people in the Battle Creek community. She was employed until very recently, until her funding was cut. She was doing job preparedness programming through the Older Americans Act, and that funding, because of federal funding disruptions, has temporarily, we hope, been cut, but she hopes to restart it soon. She will continue her education this fall as well. She got her driver's license back in 2015. She's paid thousands of dollars to get her license back, all of those tickets and responsibilities fees, bought a car. She's raised all of her, she's raised all of her children. She has 8 adult children, 12 grandchildren. She has maintained her sobriety. Ms. Raphael, how long have you been sober?
Oh, since 20, I think 2007, 2008.
Your last
off guard, I'm sorry.
Your last drug treatment was in Lansing in 2007, is that right?
Correct.
Right. And then have you gone to NA and AA?
Yes.
Yes. And she's been an active participant in NA and AA, including through treatments at Summit Point, attending NA meetings in person, online, going to NA conventions. And she has also rededicated herself to her faith. That's where she was working, but it's also her community. It's her life as well, and it's her support system. I believe she's seeking this expungement to fully clear her record. She has applied in some other courts as well. And all of those expungement applications have been granted. They were all filed simultaneously. 2 of those courts have heard those applications. One other 54A, Judge Flores, granted an application in July. And then Judge Richardson in the 10th District Court in Calhoun also granted the application to set aside all of the Calhoun County misdemeanor convictions. And so this is part of that larger effort to clear her record and improve her employment prospects moving forward.
And I did hear you said that she had gone through some recovery. Was that the underlying issue here? Because I see a long list of convictions and then some that didn't have convictions, and the ones I'm mostly concerned at this point is after 2000 and 2007, she still appeared to be engaging with the criminal justice system up until 2019. So when was her treatment?
Sure, yes. So, I mean, I believe that substance use was certainly an issue. It harmed her ability to make good decisions, but it wasn't the only issue that she was facing. She was homeless for many years. She was not working. She was not going to school. She was using drugs, mostly prior to 2014. She was, I think, depressed. She had lost her rights to her children for a time as well. She just didn't have a very stable life, and it wasn't until she was able to get that stability, get an apartment, get a house, start taking classes, get drug treatment, and all of these factors coming in line, that she was able to move forward and build a new life.
Okay. Well, I'm happy to hear that she has gotten back on track or gotten on track. It's a testimony that even with the sordid past that she's obviously had, that there's still hope and opportunity to regain control over your life and move things in a positive direction. So here you are now with an associate's degree and you're working on a bachelor's degree, and you started a nonprofit, and you can now help encourage and inspire others who are in similarly situated situations. So I applaud you for that, ma'am. I've reviewed the file. I've heard the testimony given by your attorney regarding what you've gone through and where you are now. The file also attached exhibits that I've reviewed from individuals who could also testify to your character and where you are at this point. Based on that, I've made a determination that it does warrant setting aside these convictions as it's within the interest of public justice. So I will go ahead and grant set aside these convictions. It'll be signed and dated for today. Thank you. Do you have any questions for the court at this time?
No, thank you, Your Honor.
Thank you. You're welcome. There's someone in the waiting room, a jail in the waiting room. They never got Stoudemire together, I see. Who's representing Mr. Stoudemire on this one?
I believe on his felony case, there is
There-
private counsel.
There was a private counsel on the felony case, and they did a motion for him to go undergo competency, a petition for competency.
Yeah, the public defender's office has not been filed for the misdemeanor, just to retain attorney on the felony one.
You say the public defender did not get.
There's nothing for the misdemeanor in our office. So I don't know whether they declined, retained.
It says, I arraigned him, he requested court appointed counsel.
The guy came in and I told him the light needed to be put on, but he took the remote and did something and then walked out the room. So I'm just sitting here.
Yeah, that's something wrong with the camera. I don't know why the jail didn't address it. He did request court appointed counsel, but he does have a private attorney. I don't know why the attorney didn't address. He did not file an appearance on these, that's for sure. He only filed an appearance on the felony.
And we just have no application in our system, so I can do one in today, but we have to file.
Okay, and he did, he had, apparently they believe he needed to undergo a competency, so I just signed that this morning, I think.
Okay,
The
so
petition on the
these
felony.
cases will have to stay anyway.
Correct. So if someone wants to log in and meet with him, we can't get the jail to fix his camera.
Gotcha. I'm already in one of the breakout rooms.
Why are they giving me this substance abuse assessment? Who is this for? That is for Mr. Orsinga.
Attorney.
Oh, he wants to request a meeting with sentencing. Yeah. He's supposed to be here today for pre-trial or something. I need a, criminal history.
So you go, he previously denied or declined a TD. He has changed his mind. I filled out a new application with him, but I just got a notice from my office that the address on file is not good, so address.
Well, he also has a warranted file too.
I could talk about that if I may address the court on that.
On the record in the matters of the state of Michigan versus Brandon Dennis, file number 25-01177. I have 25-01825, 1827, 1826 appearances, please.
Morning, Your Honor. Cassidy Kachikas for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter for Mr. Dennis. We have not yet filed an appearance on these. However, he did apply for me with me this morning. He is previously recently qualified, so I believe my office will be taking over these cases as well.
Okay, so you did already do intake on the others?
I
correct?
did, Your Honor. However, I just in the last couple of minutes received a notice from my office that the address we have on file got sent back to us, so I do need a new address, as I believe the court will for Mr. Dennis.
Mr. Dennis, what's your address? You're muted.
Hey, Brandon, you're muted. So if you tap on your screen and find that microphone button again, it'll let us hear you.
Oh, sorry. There you go. And so my address is 821 Mount Avenue, but it's red tag. So my mailing address now would be 2223 Portland Road, Portland, Michigan 48875, and that's my dad's address.
No, that's the address we had on this one.
Okay, we had the Mel Ave address.
Okay.
Thank you.
Okay, and then in file number 25-01177, you're in warrant status for failing to appear on August 12th.
Yeah, I didn't know. I thought they were all today. I thought that they were all put together for today. I didn't know that.
I have now explained to him that they are being pursued by different prosecutors' offices, and so those hearings will always be on separate days. So I've made sure that he needs to make sure he's making each court date as they are separate.
Okay, so a trespass on the red tag property is going to be reset on the city ordinance date.
September 23rd at 10.
September 23rd at 10, okay?
Okay.
And then the other matters which are on the state misdemeanor docket will be reset.
And if I may, on that, Your Honor, since I know we're going to take these cases, I did talk to him about how to resolve these. There is a licensing clinic happening through the Ingham County Animal Control Office on September 10th. If we could get a date on that, we can do it here at that clinic.
September 10th is the clinic.
September 22nd.
September 22nd at 10 a.m.
Okay.
No problem. Do you have any questions at this time, sir?
No, the September 22nd or 7th, did you say? Sorry. At 10 a.m.?
That's for your state file. And then September 23rd is for your city file.
Okay, September 23rd. Okay.
Okay, any additional matters, counsel?
Not for the people, Your Honor.
Nothing further. Thank you.
Thank you.
Thank you.
No problem.
I should still be in a breakout room to talk to the other person for application.
And then you have Jamie Jered here.
I believe Mr. Jared is one of mine.
You speak to Jered as well.
Yes, Your Honor, I do.
At least they're doing less with what they make, so there's no option, no change.
They're doing lunch?
Yeah.
At 10:30?
Right, that's what I said. So. She says, no,
The
no.
jail's doing lunch at 10:30, and so they can't go
No, there's not.
in the multi-million-dollar brand new jail to fix the camera.
Like, I don't have nobody over there.
Actually, I can speak to Stone.
Thank you. And I'm just resetting this, I guess.
The Stoudemire.
Yes.
Let's see.
Yeah. I'll just keep.
Yeah, all our- this is a joint to do with the goal with the felony.
With the
That's
2016 felony?
2024.
Yes, let me see.
Yes, the original was because we wanted to dismiss the district too, and then I think Steve just.
I don't
even do it, actually, in the thing.
I don't have that in my notes.
Restitution too,
I gave you Mr. USA's file because my understanding is there was going to be a request for immediate sentencing. I need it.
Thanks.
On the record in the matter of the state of Michigan versus Isadora Ursenda, 24-03-092, appearance, please.
Morning, Your Honor. Cassidy, could you speak for the people?
Jeff Cordis on behalf of Mr. Uagenda.
Maybe it's the date that was scheduled for a plea. The offer.
There was, the offer was a reduction to an OWI first offense. Furthermore, there was a kilobrute to no upfront jail.
That's correct, Your Honor.
I believe there's a second page that was missing. There's one, they put one right on the second page and the signature line. I talked to them about it, about conserving paper. They said there was nothing they could do.
It's government efficiency, right?
Exactly.
There we go. Yep.
Raise your right hand. Step forward. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. Yes. Okay, you can put your hand down. You understand each of the rights here, sir?
Yes.
You understand that you have the right to be presumed or considered innocent until proven guilty?
Yes.
And you have the right to maintain your innocence and require that the prosecutor first prove each element of the charge being brought against you beyond a reasonable doubt before you're considered guilty. You understand that? You have the right to maintain your silence and not have silence be used against you to prove your guilt. You can waive your silence and testify. You have the right to see, hear, and question in court any witness called to testify against you. You understand that? You want to give up each of those rights today? Is anyone coercing you to plead guilty? Sorry? Has there been any promises extended to you if you plead guilty? Anyone promising you anything to get you to plead guilty?
No.
Okay. Are you on probation? You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer or on a future job application? You don't understand that? If you plead guilty, you can get a conviction and you might need to tell your job about that. You understand that?
Yeah.
Okay. You also may have impact on travel or immigration status. You understand that?
Yes.
As to the operating while intoxicated first offense, do you want to plead guilty because you believe you are guilty? As to the OWI first, how do you plead? How do you plead, sir? Factual basis?
Yes, Mr. Uachenda, on or about June 22nd, 2024, were you driving a motor vehicle in the city of Lansing, county of Ingham?
Yes.
And at that point, did you consume alcohol prior to driving that motor vehicle?
Yes.
And your blood alcohol content was above a 0.08
Yes.
bodily alcohol content? And do you have any reason to doubt the validity of that test? Okay. And the consumption of that alcohol impaired your ability to operate that motor vehicle?
Yes.
I think that's sufficient, Your Honor.
Any questions from the prosecutors?
No, Your Honor.
The court satisfied with the factual basis, I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. And counsel, my understanding is that you submitted a copy of the substance abuse assessment because you wanted immediate sentencing.
I did submit that. We had Mr. Uachenda screen for sobriety court at one point. If you remember, that was unsuccessful, but we do have the substance abuse assessment. So we would ask for to move right to sentencing at this point.
You can address the court.
Thank you. Mr. Uachenda works. He's lived in the area for quite some years. Last week, or within 10 days, just had their second child with his wife. So baby's doing well. He's getting some sleep in the evening, he tells me, and has been abstinent from alcohol since the date of this accident. So it appears everything is moving correct for him. We'd request the court file the Kilgore agreement.
Sentence is going to be 6 months probation. While on probation, you're not to use, purchase, or possess alcohol or drugs without a valid prescription. You will be required to undergo preliminary breath testing and urinalysis testing, and you have to pay the cost of that, okay? You're not to use or possess a firearm, ammunition, or weapon of any kind. You're not to be at any bars or any nightclubs. You're not to engage in any assaultive or threatening behavior. And you need to provide evidence of your employment to your probation officer, okay? You'll participate in substance abuse treatment as recommended by probation. And then I'll also order that you do alcohol highway safety education. Okay? You have any questions at this time? Are you in school too?
No, I'm just working.
There's a $75 crime victim rights fee that must be assessed, plus a $50 state minimum cost. That must be assessed. And council, was there OWI cost recovery from the Lansing Police Supply? I know Lansing Police has OWI cost recovery, but I don't have it because this file was not prepared for sentencing. So can you provide that to me? And then is your office imposing the OWI cost recovery?
Just what's.
Because that is attached to the file.
Yes, Your Honor, we will be doing that. Imposing the OWI cost is 120.
Can you tell me what the Lansing Police cost recovery is? It should have been attached to your police report.
Yes.
Your Honor, I'm not seeing one in the file that links up to what the LPD was requesting. We just have our generic. If the case goes to trial, our office would be seeking a $255 reimbursement. If it winds up being a plea, we would seek $120. That's all that's reflected in our
That's
file.
from your office, but
Yeah.
when the lab results come back, typically, and maybe it's your office who's not requesting it, there's an OWI cost recovery that comes from the police department with those results. You're saying
For the per hour of like however many
Correct.
people were involved. I'm not seeing that in the file here.
Okay.
I just see our generic office form.
no restitution will be ordered for that purpose. There's a $30 per month oversight fee for each month of probation, so that's $180. Await discretionary fines and costs. Your total fines and costs is $425. And you can make monthly payments on that, okay? You'll check in before you leave today with probation. And then you'll be reporting remotely monthly to them, okay? Do you have any questions? Any additional matters for the record?
No, thank you, Your Honor.
Okay, you're all set.
Yeah.
Do you want Jered still in the room or you want her out?
She can be taken out. For Jered. I just looked up the information, so double check that I've gotten it correct here now, so this was there for the case number. Which I'll still do. That's like my file.
She just wanted to resolve.
Yeah, she's not, because it.
Ready on Jered?
Yes, Your Honor, we're just filling out the plea sheet right now.
Okay.
Oh, yeah. it's awesome. It's, well, it's not charges, but it's some kind of reject fraud. It looks like less than 2nd degree.
Okay, let's see. This was Jered. State of Michigan versus Jamie Jered, 24-01728. Appearance, please.
Thank you, Your Honor. Cassidy Kachikas for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Jered, who joins us via Zoom.
Okay, you can hear us, correct, Ms. Jered?
Yes, I can hear you.
Okay, today was the date scheduled for pretrial for a retail fraud 3rd degree. It says that people are offering for you to plead as charged with an agreement of time served, a killable agreement, and additionally pending case 06R. Is that what that says?
Sorry, I can read it out as well. Your Honor.
Yes, please.
In our files, it is 065-25004722, and that is an offense date of 06/27/2025. Police report number 25-70555.
That case will not be issued.
Correct.
Okay.
And I put a note in our file already.
Okay, and in exchange for a guilty plea on this, they will not issue a pending charge that was just stated on the record, okay? Is that what you understand, Ms. Jered?
Yes, yes, ma'am, or yes, Your Honor.
You want to plead guilty?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, ma'am, Your Honor.
Thank you. You can put your hand down. Okay, you have the right to proceed to a jury trial. You are innocent until proven guilty, and you can require the prosecutor to prove your guilt first by proving each element of the charge that's being brought against you beyond a reasonable doubt. You understand that, right?
Yes, Your Honor.
You also have the right to be silent at trial and not have it be used to prove that you're guilty or imply that you're guilty. You have the right to question or cross-examine in court any of the witnesses called to testify against you. And you have the right to subpoena witnesses that can testify on your behalf and to present evidence that you believe show a defense to the charge being brought against you. You understand that?
Yes, Your Honor.
You want to waive each of these rights today in order to enter a guilty plea to the retail fraud 3rd degree in this file?
Yes, Your Honor.
Is anyone coercing you to plead guilty?
No, Your Honor.
Any promises being made to you if you plead guilty?
No, Your Honor, no.
Are you on probation or on parole?
No, Your Honor.
You understand that if you plead guilty, you might need to put this conviction on a future job application or report it to your current employer.
Yes, Your Honor.
And just to clarify, she is about to start probation in the 55th District Court. However, that is recent as of August 5th. She's finishing some time there as well with Bonner in this case before that begins.
Oh, sounds good. Thank you. This conviction could also have impact on travel or immigration status that you may be seeking.
Yeah, yes, Your Honor.
Okay, as to retail fraud, third degree, how do you plead?
I plead guilty.
Factual basis.
Thank you. Ms. Jered, is it true that on or about February 24th of 2024, you were present at the Meyer at 6200 South Pennsylvania Avenue?
Yes,
And is that in the city of Lansing, Ingham County, Michigan?
yes, it is.
And is it true that while you were in that Meyer, you took items that were being offered for sale without paying for them?
Yes,
And those items totaled about $74?
yes,
And those items were ultimately recovered from you, correct?
yes, they were recovered, yes.
Thank you, Your Honor. I believe that satisfies the factual basis.
Any questions from the prosecutor?
No, Your Honor.
If the court finds your plea to be freely, voluntarily, and intelligently made, your plea is accepted. Looks like I did amend your bond on the 11th to a 510%. So she has at least 7 days credit. Credit time served.
Thank you.
Okay, any additional matters for the record?
Not for the people, Your Honor.
Nothing for defense.
Thank you, you're all set.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. And then I'm assuming Mr. Stoudemire is all set.
Yes. Would you say the date, please?
It's set for a review. He's good in competency. Mr. Stoudemire, if he's still there, is all set.
I'm all set.
Yes, you're all set too, ma'am.
Okay, thank you.
Thank you.
I think I did all you were talking about. Was that target on-
Am I all set, Lauren?
You are all set, Jamie. Thank you.
She didn't trust me.
I said Lauren.
No, I told her, I said, you're all set. And
Oh.
then she said,
Okay, I just wanted to make sure because they're wanting me to go, you know?
You're all set.